I've got an itch I can't scratch, I'm missing a piece that completes a whole part of me, an open wound scar to see. Everybody come here, gather round, welcome to the freak show, the best in town. What the hell's wrong with me? I don't get along with anybody, honestly. I've been living in my own head constantly, thoughts jumbled round, think I need a new lobotomy. Wait, all these thoughts are too negative. I don't wanna get lost in the sedative. Gotta show them what I got, I'm competitive. You know I'm about to go off, I won't let them win, I'll take a stab. I wanna chase the bag, I wanna way I can change all the things I lack. I gotta face the facts, I got a taste in that. Got me obsessed with the rest, I got an itch to scratch. I'll give up everything.
Sick of the venom in my brain, running from the past, wanna escape my pain. I just wanna be a better person, I deserve this, I just wanna break these chains. Always asking for greatness, true to myself, I never fake it. Seen too many once, I just so they get famous. And when I say the truth, most really can't take it. In spite of everything I've been through, I'ma make it. Fake friends, but on my downfall is toxic. Day one, started to outlaws for profit. Now all I do is write verses, no talking. All I do is put the work in, no option. This was everything I ever wanted, created a legacy off of me, just being honest. And the fake ones hate, but it's all to no avail. They wanna see me lose, but you know I never fail. I'll give up everything, daunting if I can see my dream. Cause I'll do anything. Want a reality. I'll give up everything, daunting if I can see my dream. Cause I'll do anything.
Hello, everyone. How are you? Welcome to the Freak Show, the best in town. Ha ha. Well, we'll see if this works. I have this scheduled. It's 3 hours. And then I have Chad Daybell's hearing scheduled directly after. And that's 3 hours. So we will start, you guys. Cross your fingers. Here we go.
The docket presented by Defense Diaries. We will be giving you just facts. All right, so we're back from vacation. Obviously, there is no rest for the weary. And we're back at it. So today, as we all knew, was going to be a huge day as Judge Gull's response was due to the original action for the petition for the writ of mandamus that was filed by Richard Allen, his relator and his relator counsel, Carol Weineke, and others. And so today we got a couple of responses. First, interestingly, we got a response from the Attorney General of the state of Indiana. That dropped first, and about a half an hour later, Judge Gull, her response dropped, both filed with the Supreme Court of Indiana, and both, I anticipate now Allison has read them for the most part. I'm going to be reading them to you. Allison, as always, will be giving you the law, giving you the straight dope. I will then be translating Allison's legalese to regular folk speak, and we'll go from there. It's going to be interesting. I anticipate, and without me having read them, Allison having read probably a majority of both of them, I'm anticipating the arguments are going to be similar in both. I expect both to have a very measured response in terms of what went on, and I think that initially, as we get to it, the procedural attack will probably do it. Allie, you want me to do it? Just kind of read through. Definitely want to read through the end.
Read through, like, as much as you think is enough, and then we'll talk about it after.
Well, I think instead of reading through kind of the table of contents, I mean, they're going to have everything captioned as we move along. So I think we just move right to it. You're going to have typically in every kind of response like this, whether it be appellate or whether it be at the Supreme Court level, you're going to first have your table of contents, which is going to tell the court exactly what's contained within the petition. They do have page limits. So, they're taking that into consideration when they have to prepare these tables of contents. And those page limits are strict. They're very, very strict. Like if you turn in something and file it and it's over the page limit, it'll get rejected. So it's not like close to or around. It's got to be exactly what the page limit is, which is good because that keeps things tailored to a reasonable amount of writing. So we've got, it starts off, and these are the table of authorities. Now that is a list of all the cases that have been cited, as you would expect. Both the state and the attorney general cited a ton of case law in here. Some of it looks to be persuasive and some of it looks to be binding. Binding just means that it's from the state of Indiana. Persuasive is from any other jurisdiction that is not Indiana. And as you can see, they have quite a few. So those will be like tucked in when they cite cases throughout the particular sections within the document itself. All right, so I'm going to go through and I'm going to read the intro. This court has never issued a writ to reinstate a criminal defendant's counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. In disqualifying relator's counsel, respondent did not violate an absolute duty. Moreover, relator's remedies on appeal are wholly adequate. Now that's telling you right up front, they're going with their strongest argument right out of the gate, which we'll get to. And it's a strong argument. And we'll get to it, but I mean, Allison, especially Allison and myself were screaming interlocutory appeal on this, but we'll get to that when we get to them. Okay. So moreover, relators remedies on appeal are wholly adequate. Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice or her choice through the ordinary appellate process. Whether relator's counsel withdrew or were removed, this court should deny the petition. Relator's petition further fails on the merits, and that's what I was talking about. They're first going to say that procedurally it's defective. Therefore, the court doesn't even need to go to the merits of the case, and then they could just rule that it's defective procedurally on its face. Therefore, we're denying it. And we're not going to even get to the merits. So that's her first argument in terms of what she's going to be making. But she then goes on to discuss the merits. So relator's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select his counsel. Respondent has discretion to remove relator's counsel, whereas here, the record supports that attorneys Baldwin and Rosie were providing ineffective assistance of counsel. Relator's counsel, Roman numeral 1, failed on multiple occasions to take reasonable steps to safeguard confidential case materials. Roman numeral 2 made extrajudicial statements that had a material likelihood of prejudicing the case. And Roman numeral 3 provided false information to the court. Before removing relator's counsel, respondent afforded relator with notice and opportunity to be heard through written submissions, as well as an argument in chambers and on the record in open court. So we're going to get to that. And, she's clearly, and we said this, she's going to have her position. Like she just wasn't, anybody was saying, oh, Gull's not going to respond. She was always responding to this. No sitting judge who's been on the bench for as long as she has is going to take shots to the bow without responding. And so I would have been stunned if she didn't respond. And frankly, I would have been stunned. I have a feeling that this is going to be well put together. And I think that there's going to be strong argument in here. So I'm very anxious to read it. The relator's request for this court to disqualify the respondent fails because respondent alleges no bias or prejudice against relator or his current counsel. Relator's lone assertion to the respondent's removal is the trial court's ruling to disqualify relator's prior counsel. But a trial judge's adverse rulings are insufficient to demonstrate the judge has a personal bias or prejudice. This court should deny the petition. So she gives you a summary of both arguments. Now, this is going to go through what the standard of review is. Explain, Allie, what the standard of review is just generally.
Like what consideration the court is giving something when they're looking it over. So if it's like in the court's discretion, they look at things as the standard review of abuse of discretion, and they decide, are they making their own decision or are they putting more weight on the trial court's decision?
Okay.
And I'm sorry if that was non-responsive, Bob. I was looking at a case that she cited in here, so I apologize.
Okay, so the Supreme Court has, quote, the power by writ of mandate and prohibition to confine a lower court within its lawful jurisdiction. Okay, so that's That's basically what the rule is. That's how you get up to scoring for one of these writs. So writs of mandamus and prohibition are extraordinary remedies, which are, quote, are viewed with disfavor and may not be used as substitutes for appeals. So she's putting that language in there right away. I'm just telling you all, this is her primary argument, and I fear it's a really good one because it's the rules. Sometimes them's the rules. We know what Richard Allen's attorneys and their response was to this, and we'll talk about that more in terms of why they felt they couldn't go the interlocutory appeal route. It's going to ultimately be up to the Supreme Court of Indiana to decide whether or not they're buying that argument that Kara put together, Weineke, in terms of that second original petition.
And this next part you're going to, sorry, babe.
Okay.
I was gonna say, the next part you're going to read is like the actual standard of review, like what they have to decide to determine whether or not they're going to hear a writ, issue a writ, all those things.
Okay. So original actions rule 1C, and that's what they're citing for that particular rule. So this court will not issue a writ unless the relator has a clear and unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. Okay. So the argument, so she's going to start right here with her first argument, which is the relator's petition fails the mandatory procedural requirements for seeking a writ. A relator does not have a clear and unquestioned right to have his counsel reinstated. So this court has never issued a writ to reinstate counsel where, as here, the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence, compromising the accused's constitutional right to competent assistance of counsel. And contrary to the relator's assertion, neither this court nor the United States Supreme Court has held that a trial court may remove an accused selected counsel in two circumstances only. One, which is Roman numeral 1, where counsel is not a member of the state bar, or 2, Roman numeral, counsel has an actual conflict of interest. And she's citing back to the relator's brief in support of the petition at page 15. The relator does not have a clear and unquestioned right to the relief he seeks, and she cites Woodford. Okay, to the contrary, this court in state ex rel relation to Jones v. Knox Superior Court denied the relief relator's request here. In state ex rel Jones, the relator, who has been indicted for murder and rape, requested a writ of mandamus to reinstate his attorneys, whom the trial court had removed. The court denied the petition. In dictum, explain to the kids what dictum is, hon.
So Bob was talking about some cases being, within the state and being, or otherwise being persuasive. So no, I take that back. When a court comments on something that's not the primary issue before the court. So the Supreme Court, for instance, will always say, this is the issue before the court. For example, did removal or denial of the appearance of these attorneys violate the defendant's Sixth Amendment right to counsel of choice? And then if they'd start discussing something else that's not directly related to that, they call that in dicta. So they're talking about the law, but it is not the specific law applicable to the specific issue, although relevant for some other reason.
Right. It's not the holding. It's not the holding of the decision. So it's not the rule of the case or the decision, but they do it a lot. And again, it's persuasive. I mean, you can use it persuasively, but it's not the holding of the opinion. So in dictum, the court observed that it was, quote, generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. However, the court finds it unnecessary to explicate the parameters of that authority here. And then she cites the case. This court's dictum does not provide relator with a clear, unquestioned right to relief or establish that respondent violated an absolute duty. Do you have any comment on that?
I mean, the question is whether there's been an absolute duty, and if it wasn't presented to her ahead of time, then they can sort of get around whether she had, an absolute duty to act on it or what to do.
Right. Okay. So the relator relies, for the most part, on case.
So I wonder, do y'all think that she did wrong? Or you think that she was right in making them resign instead of firing them? I think she was wrong. I don't know what you think.
This is from outside of Indiana, which was a critique by many of the particular petitions that were drafted, that they were using a lot of persuasive cases from outside of the jurisdiction as opposed to Indiana cases. I think that the primary argument back on that was this hasn't happened in Indiana in a case like this, where a judge has just removed counsel without really having an evidentiary hearing and without establishing why she's really removing them, other than a bunch of off the record stuff. So let's see how they deal with that. But these cases are not binding on the trial court. Much less do they impose on respondent an absolute duty to act. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. Relator identifies no case from this court or the U.S. Supreme Court that affords him a clear right to an extraordinary writ for the relief he seeks. All right, so that's the first argument. Clearly, in my opinion, it's the strongest argument. I think that depending on what Scoyne's opinion on this is going in, I think that she has given them a place to hang their hat if they don't want to get into the scrum. And I think that they'd be within their, within their discretion, within the law to do it. I mean, I hate to say it, but this is what we were concerned with when they came with this particular remedy in lieu of the interlocutory appeal approach, because they essentially have to win kind of two arguments in order for this to make its way through Scoyne and have them give them the remedies and the relief that they're seeking. And meaning that they would have to agree that the circumstances dictated that they had to skip this procedural step, talking about they should have filed an interlocutory appeal, had that go to the appellate court, have that get denied. And then at that point, they could go to Scoyne and say, okay, we tried the interlocutory appeal. That was denied. Now we're coming because now we have no other relief, right? So let's get to B. So the relator's remedies by appeal are wholly adequate. Okay, and this is where they're going to get into that argument that I was just talking about. Quote, all petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. Okay, and that comes from the original actions rules 3A6. Quote, far too frequently, writs of prohibition and mandate are sought to be used as a shortcut to an appeal on the merits, which, quote, cannot be done. And so she cites Durham v. Marion Circuit Court. If relator believes that cases from other jurisdictions are persuasive in how respondents should interpret the Sixth Amendment, the relator may present those arguments on interlocutory or direct appeal. Relator cannot file an original action to circumvent the normal appellate process. Indiana's appellate courts, as well as other state and federal appellate courts, routinely consider Sixth Amendment challenges on interlocutory or direct appeal, including disputes about choice or removal of counsel. Now, I know we've talked about what an interlocutory appeal is, as we have pretty commonly in the last month talked about. Since this went down, this is what we thought that they should have done in terms of the remedy. Can you just describe it again? If we have any new subs out there that have not heard and don't know what an interlocutory appeal is, just give them a generic definition.
Yeah, an interlocutory appeal means basically like in the middle. So typically we'll speak to criminal cases, but typically in a criminal case, unless a key piece of evidence has been suppressed by the state, you can't file an appeal until the end. However, denial of assistance of counsel in our state is recognized as something you can automatically file an interlocutory appeal, as it is, I know, in Nebraska, but apparently in Indiana it is not. So it's basically you have to ask the court to certify this order to allow you to file an interlocutory appeal, and that's the first step.
Right. And that did not happen here.
Right. Which would have meant that Judge Gull would have had to approve an interlocutory appeal on that issue.
But I mean, could she, if they would have said, okay, we're asking for you to certify the order, could she have refused to do it?
Well, it sounds like, based on what Kara told us when she was here, that in Indiana, it's not something that they have to approve. So not, and I don't know if that means that the judge has to approve or not approve, or the state has to hear, but it's not something that is generally recognized as an interlocutory appeal issue. However, as you'll see as you go through this, which is one of the things that I'm sort of simultaneously looking into, which is why I missed some of your earlier questions, but there have been interlocutory appeals on this issue in the state of Indiana, or at least recognized in this brief as something that can be done in the state of Indiana. Okay.
And typically when you're going to file appeal, it has to be after final judgment, right? So say for instance, in this scenario, what you specifically had been suggesting was that once Gull had said, okay, I'm sorry, Richard Allen, I cannot in good conscience allow for these two attorneys who earlier this morning filed their pro bono appearances on your behalf. I cannot allow them in good conscience to continue on as your attorneys, because I found that they've been grossly negligent, and I don't feel it's in your best interest, because I don't believe that they're providing you with competent counsel. And that was her order. So once that got committed to writing in the form of an actual court order, that's where we're talking about that we would have had to have asked, that they would have had to say, okay, we need to certify this order so that we have a final judgment of the court as to that specific issue. And at that point, they would have had the ability to be able to move forward with an interlocutory appeal, right?
They have to file a motion requesting the trial court, so in this case, Gull, by the 30th, not December 1st, not December 2nd, by the 30th, they must file seeking to have that order of the 31st certified for an interlocutory appeal if they want to do so.
Okay. And that is because there's a very strict time limit in terms of filing, correct?
Correct.
30
Which
days.
is what, if people recall, Judge Gull raised in relation to the other original action, said that too much time had gone by where on some of the issues that they complained of.
Okay. All right.
So
So
typically in a criminal case, the final judgment is like the sentencing order. That's when it's over.
okay. All right. So let's keep rolling through here. Indiana's appellate courts, as well as other state and federal appellate courts, routinely consider Sixth Amendment challenges on interlocutory or direct appeal, including disputes about choice or removal of counsel. She cites several cases, many from Indiana, and it looks like also federal cases as well. Notably, the relator cites Lotta, Hannah, Harling, and McKinnon in his petition and brief, all cases on appeal. Those cases defeat the relator's assertion that his remedy available by appeal would be wholly inadequate. So basically what she's saying, she's using their own cases against them, saying, look, you're saying that you didn't have a remedy through an interlocutory appeal, yet in your own document, you're citing cases that were actually up on appeal and dealt with the very issue that you're complaining that they couldn't deal with. Okay. Relator asks this court to use an original action to rule for the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent. But this court will consider an extraordinary writ only when the law is settled and the trial court's duty is absolute. She cites Woodford. This court should decline the relator's invitation to use an original action to alter Indiana law. Okay, now we've got Roman numeral 2. The trial court did not violate the relator's Sixth Amendment rights by removing the relator's counsel. A criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. Quote, the Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. And that comes from Wheat v. U.S. And that is a Supreme Court case. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure that a defendant will be inexorably represented by the lawyer whom he prefers. Okay, so in the first argument under that, it's paragraph A. Respondent properly exercised her discretion to protect the relator's Sixth Amendment right to effective assistance of counsel by removing Baldwin and Rosie. As this court explained, quote, the right of counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. The appointment of pauper counsel, which means that he was indigent and he was appointed public defenders, is within the discretion of the trial court and will be reviewed only for abuse of that discretion. All right, the quote, qualified right to choose one's own counsel must be placed, quote, against the backdrop of judicial discretion. Traditionally, courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. Okay, and that's, again, she was quoting a Fed case, Dinitz. And, quote, the Sixth Amendment's right to choice of counsel merely informs judicial discretion. It does not displace it. And that also is a quote from Dinitz. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused Sixth Amendment right to competent and effective assistance of counsel. This court has explained that, quote, the trial court must be given latitude in its efforts to navigate the Sila and Charybdis, I'm not sure if I'm butchering those names, posed by the conflicting Sixth Amendment and right to counsel of one's choice and a competent counsel. We conclude that the trial court's discretion is necessary because of the tension between those two important rights that must have been resolved by the trial court. Okay. So gross incompetence, and this is another quote, gross incompetence or contemptuous contempt or conduct that cannot be cured by a citation for contempt must justify the court's removal of an attorney, even over the defense's objection.
So this is the case that I'm looking at, this Harlan case. So you notice that she uses gross incompetence here, where previously she's been talking about gross negligence. Although when we read the transcript, there was some mention to incompetence as well. Although what she's been describing is not, incompetence. However, so the Harlan case dealt with this appointed counsel being removed, and it is not an Indiana case. However, it's the case that they, decided to cite to. It's an appellate case from the District of Columbia. However, in that case, it was a federal murder case, and they were looking for the names of witnesses, eyewitnesses to the case, and they filed a discovery motion, and made an oral request to continue trial, with the judge telling the lawyer, I will not be able, he said that this man will not receive effective assistance of counsel if the lawyer didn't get the stuff. And the judge cut him off, wouldn't let him talk, and immediately said, all right, you guys are off, we're appointing new counsel. And he's like, wait a minute, why? And can I speak? And she really wouldn't let him speak, and went on to say, you seem to be trying to set a record in this court for a later ineffective assistance of counsel claim. So she wasn't even going to let, she or he, obviously, I'm sure the judge, this is a 1978 case, was a he, that he would not even let the lawyer, make a record as to why the lawyer felt they needed this stuff. And the court in this case, recognizing, and this is again 1978, that the right to counsel when you're dealing with an indigent defendant is not the same as your typical right to counsel. However, they went on to say, we conclude, however, that once an attorney is serving under a valid appointment by the court and an attorney-client relationship has been established, the court may not arbitrarily remove the attorney over the objections of both the defendant and his counsel. Once counsel has been chosen, whether by the court or the accused is entitled to the assistance of that counsel at trial. So that just speaks to, the reason they cited this case was for this paragraph about, and again, in this case, it was dicta because it's not what happened. In the Harlan case, it was dicta where the court used the words that, if there is gross incompetence, they can remove the attorney, because here they clearly found that the judge was didn't do it. It was completely incorrect about how the court handled it, didn't give the lawyer to speak, an opportunity to speak, all of those things. But it looks like Judge Gull's lawyer liked the quote in here that talks about gross incompetence being a reason that a judge could remove appointed counsel. However, again, that was dicta because there was no argument of gross incompetence in the Harlan case that they are citing.
Right. I think what it boiled down to is that they were desperate to find a case where they used that term, gross negligence, especially
they didn't use negligence. They used incompetence. There's no mention of negligence here. Yeah.
So, I mean, because gross negligence just typically is referring to civil matters. Negligence is a civil issue, typically. When you're talking about if somebody was negligent, say, for instance, you're suing somebody, you say they're negligent, or if they're really, really negligent, you say they were grossly negligent. It's not something that I've heard in criminal courts relating to anything. But, I think that they were trying to desperately to find something so that they could kind of smooth over that issue for Gull, because she's gotten probably more pushback on the grossly negligent terming that she used more than anything else. It's.
Do y'all think that all of this stems at the picture leak, the crime scene picture leak? Crime scene leaked picture. There we go. I think that's where this stems from. And now that someone's charged, I don't know. I feel like he needs his attorneys back.
She came up with this term that's not used in criminal matters, and that was the phrase that she was using to remove these guys. So I think that they probably thought it was important to try to find something that was at least similar to that language, which is probably why they included that.
Right. And just to note, and maybe I'm providing too much lawyer information here, but the U.S. versus Dennett case that they they cited to in the Harlan case does not mention the word gross or incompetence. So,
or negligence. Because remember, she said grossly negligent. She didn't say grossly incompetent.
I understand that, but I'm just saying, like, gross is not mentioned in that case at all. It's clearly what they took from it, but it's not a cite. Or they would have cited the original case if it actually said that.
Okay. All right. So plowing through. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. Quote, we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. And that is a Supreme Court Shepard v. Maxwell from 1966. And she also cites Howard, which is not a Supreme Court, but is a federal case affirming disqualification of defense counsel on the grounds that the trial court has, quote, an obligation to foresee problems over representation that might arise at trial and head them off beforehand. The trial court retains the discretion to remove counsel to preserve an accused's constitutional rights to effective assistance of counsel and due process. So the respondent acted well within her discretion to remove Baldwin and Rosie over the relator's objections. The record supports that the trial court could reasonably conclude that Baldwin and Rosie committed multiple violations of the rules of professional conduct, compromised the relator's defense, and that the, quote, the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. Supplemental record, page 15. So that's a quote of her direct language. So paragraph 1 of this argument, in bold, Baldwin and Rosie failed to take reasonable steps to safeguard confidential case materials, including the crime scene photos. See Indiana Professional
You see? I knew it.
Conduct Rule 1.6, comment 16, and Professional Conduct Rule 1.15a. Baldwin's friend and former employee, Mitchell Westerman, went into Baldwin's office conference room, reviewed confidential photos of the crime scene, took pictures of those photos, and shared them with at least one other unauthorized person. Record. She's citing the record. The photos leaked to the public. Oh, wait, there's a footnote. Footnote 1, where did that come in? Did you see it? So that was at the end of the totality of the circumstances. She talks about respondent filed the transcript of the October 19th, 2023 in-camera meeting with counsel as a supplemental record in response to the relator's motion for transcript and in compliance with the court's orders dated November 8th, 2023 and November 9th, 2023. Okay. Okay, so the photos leaked to the public, which prompted the police to investigate. An individual with whom Westerman shared the confidential photos committed suicide the night after the police questioned him. Quote, record, volume 1, Rosie and Baldwin agreed to use Baldwin's conference room as, quote, home base, end quote, for confidential case materials. She cites the record. Rosie understood that Westerman would regularly visit Baldwin's office and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback. Again, she cites the record. And that's specifically relating to Rosie's, like not only Rosie's, I think it was his motion to DQ, but I think it was also in his verified statement where he was claiming that he was still Richard Allen's counsel. Okay. So Baldwin emailed confidential work product to an unauthorized person, and Baldwin and Rosie failed to timely report the leak to the trial court or the prosecutor. The leak of crime scene photos was not the first time that the relator's counsel were involved in a leak of confidential case materials. In December of 2022, Baldwin sent an email to a person named Brandon Woodhouse, a defendant in an unrelated criminal case, who was represented by Andy Baldwin at some point. That contained an outline of the discovery materials the state had provided to Baldwin. Baldwin apparently intended to send the email to Rosie. Okay, Baldwin and Rosie, and they both have the first name Brad. So I guess what had happened, the story is that it had auto-populated his email. Andy wasn't real thorough with that, just clicked on it, didn't check. I mean, I've done it before, not in cases, but, you know, I mean, it's like, I can see how it can happen, but as you can see, if you're not careful with it, comes back in a massive way in terms of a big case like this. Frankly, in any case, you know, if you're going to be sloppy like that, you know, it could come back to haunt you, which it has here. Baldwin and Rosie did not promptly notify the trial court or the prosecution of this leak. So Baldwin and Rosie made extrajudicial statements, and this is paragraph 3, that had a substantial likelihood of materially prejudicing the case. So the Indiana Professional Conduct Rule 3.6, Baldwin and Rosie issued a press release on November 29th, 2022. And that is, again, referencing back to the record, they included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed the relator's innocence. Okay, Baldwin and Rosie did not limit their press release to information that Rule 3.6 expressly permits, nor did they confine the press release to the information necessary to mitigate adverse publicity under Rule 3.6. So that's the equivalent of the safe harbor rule. All right. So in the safe harbor rule basically says, in general, that defense counsel or the state, for that matter, has the ability to be able to make what they call an extrajudicial statement, typically to the press, wherein they feel that the other side has made statements in public that have created a certain, or may have created a certain bias with the public with respect to one side or the other, whether it's the state or whether it's the defense, and that in order for the other side to even the playing field, that they may counter that statement with a statement of their own. And if it's, and the hope being that it's going to balance those two things out and once again, even the playing field. You have anything to say about that, Allison?
I mean, I have a lot to say about a lot of stuff. I'm just trying to figure out if it's best to just wait, like I'm just,
let's get through it. We'll give our comments on it. Let's just get through it.
I just have one question for you while we're here. So are they talking about that they being the defense didn't inform the state or the judge about that very first, email, or about the about Westerman, because didn't they inform the state and the judge?
Hold on, sorry, I got to pull off for 1 second. Deal with it for 1 second.
Okay, all right. So what I'll talk about while he's gone is, a couple of things. She's talking about gross incompetence, but all of these allegations that she has, thrown in here don't really amount to gross incompetence. And this whole argument that she made about, she used her discretion effectively, I found that to be an extremely weak argument. She didn't correspond one case to a situation where that type of conduct, the type of conduct that she's complaining of, is even borderline incompetence, let alone gross incompetence. I don't know if Bob wants me to keep going or, okay, so I'll keep going. Hold on, because I've got some notes here. And then again, they complain a lot in here about the state. The petitioner, so Alan's attorneys, relying on, case law that is just out of state or another jurisdiction. As you can see throughout here, Judge Gull does, the exact same, type of thing. I was just looking to see if you guys had mentioned anything that was worth putting forward. But another thing that I noticed here, and I'm just not sure if Bob got to it yet, but they talk about how at the hearing they didn't make any objection. It says that that when they talk about where she acted within her discretion to remove them, and that when they had this additional hearing on their motion to appear pro bono, that they presented no evidence in opposition to that. But they were not given the opportunity to present evidence in opposition to that. And they were not given the opportunity to even know that she was going to rely on all of that right then and there. Again, what should have happened if she was going to remove them after they filed their appearance, what she should have done on October 31st was say, I see that you've entered your appearance. I think you're subject to removal, and we're going to set a disqualification or removal hearing for, X date, and taking it up again at a future time where they had the ability to, respond. But what took place in that courtroom on that day was not time for them to put on, witnesses or evidence that contradicted these, what's more gross negligence than competence. And you'll also, they didn't cite anything that, defined gross incompetence to fit in the four corners of what we're talking about here. I see Bob is back. Thank you very much.
Okay. Sorry, y'all. I had to, we've got kids and real life family stuff going on sometimes, especially around this time for us. It's like 4 o'clock. We got softball practices and stuff going on. So, so we apologize for that, but it has to be dealt with. All right. So you want me to just keep rolling through?
Yeah.
Okay. All right. So again, we're going back to, and I have very strong feelings about this too. And again, we're defense attorneys. So, we are always, not always, but for the most part, typically going to be siding with the defense side of things, especially in issues like this. It's just understand that. That's not to say that I will not discuss the state's position or the judge's position and not acknowledge if they were correct in their findings? Or
I think we're all pretty much on the defensive side on this one.
But in terms of, we especially something with like the safe harbor rule, we have experienced something eerily similar to this case in a case that we handled in Omaha, Nebraska. And like this exact issue came about. And that was after 3 years of the state leaking evidence to the press in a case that was not sealed, but it was still evidence that should never have been out. And somehow the press kept getting it. And they kept, like, they would know about motions that were being filed before we did, before they were to the clerk. And it was just like, so we felt we should have had the opportunity to be able to balance even the playing field out. And, but when they want to get rid of you as defense counsel, they get rid of you. And so like we've got personal feelings about this that go just beyond it, but like, we're going to give you just facts, and we're going to give you, but I want to be clear that yes, when I look at this and I look at the situation that's been happening for the past month and a half, that it has a very familiar feel to it for Alice and I personally. Just to give you some background in terms of when I'm looking through this stuff, it's giving me like PTSD in terms of, what we went through in Omaha. It was just eerily similar. I'll just leave it at that. Okay, so moreover, at the time of the press release, Baldwin and Rosie knew that the state had filed a motion for a gag order, which was pending before the trial court. I don't know if that's relevant. Like the state filing a gag order and it's pending, it's not an order of the court, I mean, it's just, I don't know, it's nitpicking, and it's not something that you have the ability to remove counsel for. I'm sorry, it's just not. So Baldwin and Rosie's decision to issue the press release prompted the trial court to issue the gag order. Well, was it that, or was she going to issue it anyway? I mean, it's convenient for her to say that it was because of that, but as she just noted, it was already out there. I think the likelihood, because of the bloodlust of this case, as Judge Diener had once coined that phrase with respect to this case in particular, I think that was a freight train that was coming into the station either way. And I think that the defense was able to do it in a very unusual move. Like, I personally, again, from a defense attorney's perspective, I respected the hell out of it, because in every case that we ever hear about in terms of a PCA dropping, where there's been an arrest warrant that's been issued and there's been a probable cause affidavit that has been attached to a complaint for a search warrant, we are getting the state's theory of the case. And that's all that is. I say it all the time. It all relates to evidence that has not been vetted at trial, just like anything the defense says for both sides. I say this constantly. Everything that we're hearing right now, them's just words. It's just each side's interpretation of the evidence that's out there. We have no idea what other evidence there is or what evidence is lacking. Everything that we're talking about now is speculative. That's why I rarely talk about the case itself or the innocence or guilt phase. I'm focusing in on the law and the procedural aspect of what's going on right now, because frankly, we don't know anything. And that's facts. And if you follow our podcast or you follow us on Twitter, like I could not be more clear that the probable cause affidavit is nothing more than the state's theory of their case based on their interpretation of the evidence recovered by law enforcement. That's their theory. It's nothing more until it gets vetted at trial, if it goes to trial. And it's the exact same thing with anything the defense puts out there. But the one thing that is that both of them are coming with their interpretation of actual evidence. The defense isn't making up things. I assure you that everything in the 136-page memo came from the state handing them the discovery, and they found it in the discovery, and it's their interpretation of it. Now that has to get vetted at trial, just like the state's interpretation of the evidence that they put in their PCA and whatever else they may have gotten after the fact, after the arrest. If they've gotten more evidence, it'll be presented at trial and it'll be vetted. It'll be tested. That's the case. That's why we have trials. That's why I just always reject people when they're saying, oh, he's guilty, he's not guilty. I lean not guilty, but like I've said, if they have more evidence that puts him at the scene and shows to me beyond a reasonable doubt that he committed the crime, then.
Is he saying not guilty because he's a defense attorney? I think not guilty as well.
I'm thrilled because then the girls got justice and the state was able to prove it and they got the evidence to prove it. But that cannot happen until trial. It's that simple. It's that simple. All right. So Baldwin and Rosie's decision to issue the press release prompted the trial court to issue the gag, blah, blah, blah. I read that already. Baldwin and Rosie issued the press release knowing the trial court would likely soon issue a gag order. Okay. Paragraph 4.
Likely.
Right. I mean, so Baldwin
and again,
and Rosie,
it's not incompetence.
No, it's her taking issue with the way that they're defending the case. I mean, it's like, that's what I'm saying. It's unusual for the defense to be able to get their side of like their version of a PCA out to the public. It's just unusual. I personally love the move because for once, instead of us all sitting there for 3 years bickering about the probable cause affidavit and the information contained within that. I mean, look at the Idaho 4 case, for instance. Like I stepped out of that completely in terms of, because all it is online and on socials is people bickering about what limited information was contained in that PCA as if they're ever going to win an argument about it. You can't. You just wait until.
Thank you very much, Mr. Bob. I've been saying the same thing. That's why I don't talk about it unless something new comes out, because you're just going to say the same thing over and over again. Just like they're saying here, you don't know what evidence they have. They have more than what you know. And everyone's like, oh, I can't convict them with the evidence. You can't convict them. You're not supposed to convict them. Oh my God, dude. You don't know that there's obvious. Dude, they're not going to put death on the table if they don't have more evidence. That just doesn't make sense at all. And just, I'm not going to talk.
Until it goes to trial. I've never seen a bigger waste of time and energy than people bickering about the evidence in that case that was merely the state's interpretation of the evidence that the law enforcement put together. That's all it is at that point. It is nothing more. And so when the defense got this out in a case like, and people are on both sides, it's just as heated as this. I look at both sides of that with people screaming at each other and blocking each other and just like, you're an idiot and I hate you. But like, just everyone needs to take a step back and chill. Like, seriously. Like when we're talking about this is procedural. This has nothing to do with the guilt or innocence phase of this trial. Nothing. This has to do with the constitutionality. This has to do with Richard Allen's constitutional rights, whether or not they've been violated, and whether or not the girls are going to get a fair trial in terms of their search for justice. And the only way that happens is by Richard Allen getting a fair trial. And it's that simple. And like all that we're talking about here, you're going to be very hard pressed to find me talking about guilt or innocence phase anywhere, other than early on when I gave my assessment of what I thought of the evidence contained in the state's theory of the case, which was the PCA, which I think is weak. I still think it's weak. Like I just do. I don't think that Richard, I'm not going to even get into it. I've said I've got so much content out there with it. I'm not going to bore you with it again. All right. So at the hearing, the state presented evidence that clearly, so I skipped something. Professional Conduct Rule 3.3a, on or about June 20th, 2023, the trial court held a hearing on the relator's motion to reconsider safekeeping order. Okay. At the hearing, the state presented evidence that, quote, clearly demonstrated the falsity of the relator's claims. The trial court issued an order on the motion finding that, quote, the evidence presented at the hearing did not support many of the allegations advanced by the defendant counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at Westville Correctional Facility, end quote. As a result of these events, the trial court became, quote, gravely concerned with the relator's, quote, rights to have competent, non-negligent representation. So it's at that point, after she sat there in the hearing for the safekeeping hearing, when she heard a bunch of self-serving testimony from the warden of Westville Prison, that she came to this conclusion. And I say this to both sides. Forget what side of, again, the innocence or guilt that you're on. Does anybody honestly think that in a prison situation where you've got a warden that's coming into court to testify, that warden is going to make admissions to wrongdoings in an open court relating to the inmates that he's housing? I mean, this argument that she keeps making is so weak. It has no substance. That's not proof of anything. That is a self-serving testimony of a warden who just came in and said the opposite of whatever was being alleged. No, that's not true. I mean, we have no way to prove it. Richard Allen and his defense team have no way to prove it. They don't when us as attorneys, we are allowed back into prisons to visit our clients. I just want you guys to understand, we are not taking tours. We are not going to where they are housed. We are brought to a room, a small conference room. We are placed in that room and we sit there and we wait while they go get our client. And then they bring our client in and they stick them in that room and that's it. And then we have our discussion. Now here we know. And like the fact that she heard the testimony that they actually were recording, which was the most egregious thing that was presented. They actually admitted to doing. It's shocking to me, which was the fact that they were using a video camera to videotape his attorney-client meetings to prepare for trial, and that they were turning his chair around to face the window so they could see his mouth moving. Like, that was by far, like, walking out of that hearing, that upset me more, and probably because I'm an attorney and I'm a defense attorney, and that would be incredibly upsetting to us if we were trying to prepare for trial, if they were.
I have no idea why they allowed it, why they didn't say something. It's definitely not right at all. And that's why I think that Odinism has something to do with it. But again, it's my opinion.
Doing that to us. And, you know, and for her to have heard that testimony and them admitting to doing it, for her to find the stuff like, oh, well, you know, yeah, he's not sleeping on the floor. He's got a bedroll just like everybody else. He's been on a hunger strike. We're not starving him. He's eating mail. We're not stopping the mail from coming to it. You know, like that kind of stuff, which is all super collateral. You know, like it's like, if we have a client that's telling us something that is happening in jail or a prison in this situation, we have no choice but to believe what they're saying. Like we have no other way to try other than to try to speak with the prison themselves or the warden, which I'm sure counsel did. They asked for them to be able to go on tours. Like that was testified to. They asked, hey, we got to see what's going on in there. They were denied that, you know, so they took precautions before probably repeating what Alan was telling him was going on in the jail, you know? So I don't know. I mean, this is deep into it, but like, this is like for her to say, like, my whole issue is she's saying as a result of these events, the trial court became gravely concerned. Now, is she talking about this, or is she talking about the culmination of the three prior? She's got to be talking about all three, right? Can't just be that. I think you're on mute. You're on mute.
Yeah, I think because she says the culmination of these events.
Okay, so you think she's talking about all of it? I mean, that makes way more sense.
Give her the benefit of the doubt.
Right. Okay.
Going to not be able to give it to her in so many other places.
All right. Okay. So the record demonstrates the trial court, based on the totality of the circumstances, could reasonably conclude that counsel's representation of the relator fell objectively short of prevailing professional norms, and that counsel's deficient performance prejudiced defense in violation of the relator's Sixth Amendment right to competent counsel. See Conley v. State. Okay, and then she cites the holding from that case, or at least dicta. It's got to be the holding because she didn't cite it as dicta. Counsel is ineffective where, one, counsel's performance was deficient based on prevailing professional norms, and two, the deficient performance prejudiced the defense. I don't think that any of those.
People should note that is the definition of, under Strickland v. Washington, of when counsel is ineffective on an appeal. So that's completely different. We were talking earlier about the standard of review or the applicable standard. That is the standard when you are trying to decide whether a defendant's conviction or a court's ruling should be reversed or overturned because they were denied effective assistance of counsel. She's, you know, where is she tying this definition in with gross incompetence rising to the level of disqualifying counsel?
Right. Okay. Okay, the professional norms in Indiana are violated when counsel fails to safeguard confidential case materials, provide false information to the court, and makes extrajudicial judicial statements that are likely to prejudice the case. Okay, and respondents filing complaints against Baldwin and Rosie with the disciplinary commission would not have ensured that the relator would receive competent representation through the remainder of the proceedings. The trial court's decision to remove Baldwin and Rosie did not violate the relator's Sixth Amendment rights. Okay. All right. So B, the trial court afforded the relator adequate notice and an opportunity to be heard before removing his counsel. Relator argued that removal proceedings should occur at a hearing where the defendant has his chosen counsel and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. She cites the brief there. Relator cites no Indiana rule, statute, or case requiring notice, a hearing, or an opportunity to be heard. In any event, the record confirms that the respondent provided relator with ample notice that the trial court was considering disqualifying Baldwin and Rosie before October 19th, 2023. And then she's going to go through the timeline here. On October 11th, 2023, the relator wrote a letter to the respondent requesting that Baldwin and Rosie continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rosie's DQ. Okay, on October 12th, Rosie wrote a letter to the respondent arguing why he and Baldwin should not be disqualified. And that, again, they're citing the record here. And then on the morning of October 19th, 2023, an attorney representing Baldwin filed, quote, a memorandum regarding possible disqualification and sanctions. And that was David Hennessy. Relator had adequate notice and opportunity to argue against respondents' disqualification of Baldwin and Rosie. Baldwin and Rosie also had the opportunity to proceed with the scheduled court hearing on October 19, 2023, but chose to withdraw instead. At the October 31st, 2023 hearing, Baldwin and Rosie further argued against their disqualification after filing new appearances, and the trial court afforded them an opportunity to be heard on the record, including via Baldwin's counsel, and that is the record, volume 2. The trial court afforded the relator adequate process, and that is her position. Excuse me. And Roman numeral 3. Do you have anything to say about that, or you will just wait?
I'll just wait.
Okay. Paragraph 3. The relator's request for this court to order respondent's DQ fails because respondent has shown no bias or prejudice towards the relator, his current counsel, or his former counsel. So the relator's assertion that a respondent must be disqualified because she removed relator's former attorneys is flawed. First, Baldwin and Rosie no longer represent the relator, and relator does not assert that the respondent has any personal bias or prejudice toward himself or his current counsel. Second, on the merits, relator presents no relevant facts supporting the relator's assertion that the respondent is biased or prejudiced against the relator's former counsel.
I'd like to chime in now and not wait, because I think her saying that she's too afraid to have him in her chambers indicates some sort of bias.
Do you?
I mean, defendants go into chamber things often. The fact that she is saying that I don't feel comfortable with this guy in my chambers, I don't know.
I mean, I get the argument. I mean, like on its face, I disagree. I think that it's not uncommon for judges not to want alleged killers to be in their chambers. I don't think that that's crazy. I do think that it shows, while it's a reasonable request by the judge or a reasonable decision by the judge, I do think that it does show that she probably thinks he's guilty. I do think that it shows that bias. All right, I got to turn on my light. It got real dark real quick, so hold on.
All right, well, I'm going to go on record saying I officially think it shows a bias, personally, even though Bob does not, and that's why, we often don't agree.
Okay, it's true. We often don't agree. All right, and let's see. Okay, and this is a quote from Zavodnik. Judges have an affirmative duty to preside over cases unless DQ is mandatory. A judge shall hear and decide matters assigned to the judge, except when DQ is required by 2.11 or other law. DQ is mandatory in the rare instance that the judge displays a personal or individual bias against the litigant or the litigant's lawyer. And then the Code of Judicial Conduct 2.11A1. Moreover, as the commentary to the Code of Judicial Conduct emphasizes, a judge's unwarranted disqualification compromises the system of justice. Okay, so, and this is like when they indent something in like a pleading like this, it's a quote. So you won't see the quotation marks, but you can know that it's actual quote of the language. Unwarranted disqualification may bring public disfavor to the court and to the judge personally. The dignity of the court, the judge's respect for the fulfillment of judicial duties, and a proper concern for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Okay, and this is how she responds to it. The law presumes a judge is unbiased and unprejudiced. Okay, and then she cites a couple cases. To overcome this presumption, relator must demonstrate actual personal bias. Willis v. Dilden. Actual bias or prejudice. And so when you see this, okay, when you see this in a pleading, what they're doing is they're citing cases. They're taking language from those cases. And now these aren't necessarily holdings. These are just language that are in these cases that support their proposition that they're putting forth. Okay, so that's when you look through these types of things. These aren't necessarily holdings from the case, but they're language that is used in opinions, in cases that support, and both sides do this always. And, in these quotes that she's using are supporting her position. Okay, so actual bias or prejudice exists only where there is an undisputed claim of judicial bias or the judge has expressed an opinion on the merits of the controversy before her. Okay. And adverse rulings and findings by a trial judge are not sufficient reason to believe the judge has a personal bias or prejudice. The mere assertion that certain adverse rulings by a judge constitute bias and prejudice does not establish the requisite showing. Okay. Do you have any comments on that?
I mean, didn't we decide I'm going to wait?
Okay. All right. So Baldwin and Rosie no longer, and this is paragraph 8, Baldwin and Rosie no longer represent the relator, and the relator alleges no bias towards himself or his current counsel. Respondent removed Baldwin and Rosie from representing relator on October 31st, 2023. Respondent appointed new counsel, Robert Scremin and William Labredo, to represent the relator. Relator is represented in this original action by Mark Lehman and Karen Weineke. Relator accuses respondent of exhibiting bias or prejudice exclusively towards Baldwin and Rosie. Relator never suggests that respondent is biased or prejudiced against relator or his current counsel. Given that Baldwin and Rosie are no longer counsel of record, relator's sweeping assertions that for, quote, all rulings going forward, the public will question the judge's impartiality, end quote, and that a new special judge must be appointed to restore the public's trust in the integrity of the judicial process, amount to blind speculation. Okay.
All right. So do you think that it's implied in there that it's a bias against Allen? In the filings that Baldwin and Rossi have done, and in the filings that Kara and the other lawyers have done?
I mean, do I think it shows bias?
No, that it's implied that what they're arguing is that this shows bias against the defendant, Richard Allen.
Well, yeah,
like
of course.
I mean, clearly they're not saying this judge just doesn't like us as lawyers. They're saying this judge doesn't like us as lawyers for Allen,
Right.
you know, and then it speaks to a prejudice towards Allen to just, you know, remove his lawyers in the manner that they are doing. I don't know. I just think it's a weak argument.
No, I agree. And I think, look, at this point in the process, as much as I want Rosie and Baldwin back on the case because that's what Richard Allen wants, and because I think that they're the best counsel that's available for him, and they have worked for a year on the case, and it's going to get the case to trial.
And because it's what I want to. And probably you.
Way faster, that's good for the family. Like everything about it, is like the decision to pull them for what she's claiming that she pulled them for. Just number one isn't enough to override, because everything at this point, all that matters are Allen's rights under the Constitution. That is the phase of this thing that we're in. And like, that is what we have to be looking at. That's what we have to be focusing on. So yeah, I would assume that the Supreme Court would make that assumption, right? That the only thing that they're really relating to is that she's showing a bias towards Allen by way of removing his counsel. The things that she's doing are showing a bias towards Allen, not towards her counsel. I take it that way when I'm reading the pleadings. Because the attorneys, it's not their constitutional rights we're worrying about here at all. Okay, so B, the relator fails to show that respondent has actual bias or prejudice against Baldwin or Rosie. Even if Baldwin or Rosie still represented the relator, respondent has exhibited no actual bias or prejudice against them. The relator offers a scant 2 sentences to support his assertion that the respondent has exhibited bias or prejudice. According to the relator, respondents, quote, finding the counsel were grossly negligent and publicly proclaiming that she had, quote, grave concerns about the representation, end quote, warrant the respondent's DQ. But a judge's findings adverse to a party do not show or even imply bias or prejudice. And she cites LG, which is a Northeast Third, which is a federal case. Excuse me. Further, these findings do not demonstrate actual personal bias. Respondent did not state that she had, quote, grave concerns about Baldwin and Rosie personally. Rather, she had concerns only about the representation of relator and his right to competent representation. Respondent's legal findings regarding Baldwin and Rosie's representation are insufficient to overcome Indiana law's presumption that respondent is unbiased and unprejudiced, citing Willis. Okay, and then paragraph 4, the court. So, like as she goes through, like these are the arguments that go to merit, like the merits of the petition. When you see one that's 4 sentences long, she's not putting a lot of weight into it. She's not giving it a lot of credence in terms of the argument or strength of argument. Like every time you're going to read a pleading, you're always going to read the strongest arguments first. And as you progress through it, the weaker arguments are saved for last. It's like sometimes, that old axiom, like save the best for last in legal pleadings, does not apply. Like, because if you have something like you always worry about a judge or a jurist like losing steam towards the end of your pleading. So you want to fire your best arguments right up front and like set their mind to like, all right, I'm here already. I'm with them because I think they're right on this point, which we'll get to, but I think that may have occurred here. Okay, the court, so the relator requested this court reinstate the January 2024 trial date, but the relator's counsel requested the trial continuance because counsel would not be ready to try the case in January. So, like this argument is she's just ignoring, she's pretending, Baldwin and Rosie don't exist. And by the law, she's correct. His new attorneys on the record made a motion to continue the trial. We all know what the remedy that they're seeking is, which is to get these two guys back on the case. But as the case is currently situated, it's an accurate statement. Okay, the court should deny the amicus request to refer the appointment of the replacement counsel to the state public defender. So the amicus Indiana, so this is her addressing the amicus that was filed by the Indiana Public Defender Council. They argued that the trial court's appointment of the relator's current counsel was procedurally defective, but relator raises no objections to the respondent's process for appointing new counsel to replace Baldwin Rosie. That's ridiculous. Like, how is he doing that? How is Richard Allen doing that? Amicus may make arguments in support of the relator's request for relief, but the court should not entertain amicus. The amicus's separate request for relief. Neither the IPDC nor relator assert the relator's newly appointed counsel, one of whom, as the IPDC notes, is Allen County's chief public defender, is incompetent. The IDPC merely claims that the trial court circumvented the county's comprehensive plan for the public defender's assignments. However, the trial court has the discretion to appoint both counsel other than counsel provided for under the board's plan when the interests of justice require it. So the trial court's method of appointing the relator's new counsel did not violate Indiana law, the Sixth Amendment, or any other absolute duty under the law. Conclusion: respondent, the Honorable Francis J. Gull, respectfully requests that this court deny the relator's verified petition for writs of mandamus and prohibition. So there you go.
It's something.
Yeah, I mean, look, my first, and all of those on the side of, we like to see Rosie and Baldwin, back on the case, which I know it's split out there, and that's people's prerogative. I mean, I think that my fear is that the Supreme Court is going to look at this, because I think they're correct. I think that they're going to find that it's procedurally defective. I think that they're going to find that they should have filed the interlocutory appeal, and that
they could have appealed from the order either denying allowing them to appear pro bono, or the order denying the attorney that the lawyers hired's motion to reconsider. I mean, they made a decision to do it this way. This was how, when we asked them about it, we had Kara on, like, why did you decide to rely on the failure to reinstate as opposed to the denial, declining to accept their appearance? It was, an educated decision. But at that point, we had some concerns, like they should file an interlocutory appeal, or they should have included in here the denial of some additional orders. I do think with what they have written, it is still possible. Well, I don't know, because that it's still possible that the court could find that the removal of them, the first withdrawal, is actionable. But could they also, hang their hats on the fact that they did have another available remedy, that being an interlocutory appeal? That's possible. I don't think this motion establishes what she says, that she was acting within her discretion and that there was no abuse of discretion. Because
how is that going to overcome the procedural issue? Like I don't think they're going to get to the merit. Like, it's either going one of two ways. All right. It's either, if the court finds that the relator, that Kara and Mark Lehman's argument was sufficient, that they could skip that step, and then they get to the merits of the case. That's a whole different thing. What I'm concerned about is that they're going to find it deficient procedurally, that they're not going to even get to the merits, because it's the easiest thing for them to do. Like, I just think that the Supreme Court is going to be remiss to get into the middle of this fight, to pull a sitting judge with this much time on the bench. I'm worried about it. I think that they should have listened to you. They should have filed the interlocutory appeal. I mean, and I get why they did it. And we asked.
Well, they couldn't. I mean, they initially.
Why don't they just go represent Richard Allen?
Rossi and Baldwin couldn't, because they weren't the lawyers anymore. And initially, Kara, right, exactly. Initially, Kara was filing as like a public person initially, but I thought in the second one, she's actually representing Richard Allen.
She filed a limited appearance on both. So, but it's limited. I mean, she's not. She's a relator. She's representing him. She's not representing him in the underlying matter, which is where I think, which was your point. like your point, and you've said it multiple times, that Richard Allen needs to still write a letter to his current counsel. If he wants Baldwin and Rosie back, he's got to write a letter post haste immediately, because it's the 27th today, state, and he's got a carbon copy of the Judge Gull, saying, I am requesting that a interlocutory appeal be filed on my behalf relating to the judge's decision to not allow my attorneys of choice to enter their pro bono appearances in this matter, so that it's of record, so that he's established it. Only to that narrow issue. It's the only way. If the 30th comes and goes, it's dead. And it's dead. Like, and correct me if I'm wrong, it's like it's dead on appeal as well. Like, he's not going to be able to bring up the issue.
No, I don't think, since it's not a mandatory appeal, I don't think it's dead on appellate issue, but it could be dead interlocutorily unless, like, let's say a new judge is appointed or Gull grants him time. For example, if he's not able to communicate, or, you know, if some of the things we've heard about him not getting or being able to send timely mail holds up, you know, his communication, they might be able to, you know, extend that within the court's discretion. That's in the court's discretion, though.
Yeah. Man, I'm concerned. Like, I mean, I always knew they were going to come with this argument. You know what I mean? But it's like, I'm so concerned that they're not going to get to the merits, because the merits is where it's the winning argument. You know what I mean?
Well, we had Kara on, and I don't remember if we asked her, because I know it was something we raised, and even a lot of your listeners asked the question, like, is the fact that the Supreme Court set it for, you know, ruling, or I'm sorry, for responses to be due, them saying they've gotten over the initial hurdle of being able to get heard there? Because I think the court could have sua sponte. I don't know if they admitted, and I know there was something in their motion that they admitted that they didn't do one of the prerequisites, and I can't remember what it is right now. But, you know, maybe we can try and get clarification from Kara about whether it's something that they would have noted at the.
Do y'all want to hear them discuss this, or do you want to go straight back to the, there you are, Berto, to the documents? Hear them discuss it, or go straight back to the documents? Let me know, and I'll do whatever you.
So, you know, a couple of things that I found interesting from where I got through on the Attorney General's response is that in their introduction, they note, is this the introduction? In their background, they note that you know, like, first, the judge found that the improper comments to the public, i.e. the press release, was potentially violative of the ethics rules. So that's clearly not incompetence, let alone gross incompetence. Again, there was this argument that Baldwin negligently released the discovery to Brandon Woodhouse, and then he did not alert the court or the state to the release. You know, it was at some point, I thought, provided by Baldwin, wasn't it?
I think so. Yeah.
Again, the issue. Go ahead.
No, I mean, to me, the whole thing is going to boil down to, like, I just don't know if we should spend the time arguing the merits of it right now. Like, I'm so uncertain that they're going to survive, you know, the condition precedent issue, which just means that they had to file the interlocutory appeal first, that they had to try to exhaust all their remedies prior to coming to this, representing him competently, where she hasn't even looked at the evidence.
And I also don't think it's worth us attempting to speculate. You know, there are a couple things, Bob, though, that I do think are really interesting in the Attorney General's response. You know, we don't have to put the whole mentioning. It was actually the one I was starting to before we got this, the order, the judge's response. But anyway, they go on to also say, but appellate courts have reviewed discretionary removal of counsel through interlocutory appeal. and they cite some cases there. So again, that answers the question of which court would this go to. Based on this, it would go an interlocutory appeal in this case, unless those cases were not, first degree murder capital cases, which might change it. And maybe, is it Travis?
Yeah, Travis.
Maybe Travis knows whether if it's a capital case, appeals, interlocutory appeals would go directly to the Supreme Court or also to the regular appellate court. But it goes on to say that removal here was at the discretion of the trial court, so a mandamus is inappropriate. And they go on to talk about how, the law does not place an absolute duty on courts not to interfere with the attorney-client relationship, right to counsel of choice. So, and again,
which to me, if they've got, because you and I had the conversation about when I was driving to Delphi on the morning of the 31st, and I knew that they were going to be entering their pro bono appearances. And I asked you, I'm like, you remember having this conversation? Not on a live, obviously, but I'm like, yo,
right.
Are they going to be able to block? Is she going to be able to say no? And you're like, no. No. Is there an argument to be made that once they got their appearances on file?
Berto, I asked, and they said that they wanted to go straight to the documents, and they're not reading the documents. I'll stop.
That's
Absolutely.
it?
Absolutely. 100%. 100%. She needed to have a removal. She needed to have a removal hearing. She needed to go through all the steps. I mean, there is no doubt in my mind that what she did there, when it is them entering their appearance pro bono, would be reversed and overturned. I feel very strongly about that.
Right, because at that point it changed. Like, this evaluation became moot, like, because they were no longer appointed counsel. They shifted from being appointed counsel to then being counsel of choice by way of entering their appearances pro bono. So that, which means that they weren't going to get paid for it. They're going to do it on their own dime. And like the counter of that argument has always been, well, look, they were doing that. There's no way. And look, we know that a case like this is a practice killer. However, when you couple that with the fact that they are stating that they were ready to go to trial in 2 months, now a month and some change, that changes it. Like, could they go on for 3 years and survive it? Could their practice survive it? No way, financially speaking. But if they were truly ready to go, which I have no reason to believe that they weren't, Go ahead.
No, I'm sorry.
No, it's all right. I was basically done.
So let me go on with this, because now I'm continuing on page 13. So they cite this new case out of Colorado, but that Colorado court recognized that indigent defendants have, quote, an interest in continued representation by appointed counsel if they can demonstrate that prejudice would result from substitution with a different court-appointed attorney. Trial courts must give great weight to the defendant's preference. Whether requiring a presumption or weighty consideration, trial courts must weigh defendant's preference for representation against the circumstances favoring disqualification. That did not happen here. But number two, right here, is that the right to counsel must be balanced against the need for a fair trial. They go on to talk about the circumstances that Ellen says in this original action, why they can remove counsel. And they talk about the serious potential for a conflict of interest. And what was the second one? Two circumstances.
Do you need me to pull it down?
No, I'm looking at it. Oh, the first was if they were not admitted to practice. Okay, but then the Attorney General goes on to say counsel's conduct or personal circumstances may justify removal. And he cites that Harlan case again for gross incompetence or physical incapacity of counsel, or it's another word for contemptuous. It's contumacious, but it's basically contemptuous.
Right.
But it's an old case.
Old-timey language.
That means that you're like not listening to authority and being stubborn and refusing to, abide authority.
Right.
But it also notes that they can, in some circumstances, can be for a removal of professional conduct, and that was in a Indiana case. But they go on to say, and a defendant may not insist on counsel of an attorney who has a previous ongoing relationship with an opposing party. But the next paragraph says that when you go down, I'm sorry, it's 2 paragraphs. It's C. They go on to say the record prevents review of counsel's disqualification. Defense counsel's withdrawal truncated the proceedings. The present record prohibits complete review of whether the trial court's concerns justify substitution of counsel. In chambers prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified that it intended to address in the hearing. The prosecutor was prepared, somebody was prepared to present evidence from the leak investigation. I just say that because the defense wasn't given the same opportunity to be prepared, but the hearing did not occur because defense counsel withdrew rather than challenge the factual allegations at that time.
So how much weight do you give to the argument that they're stating that they have cited no statute, no local rule, no nothing that says that the judge has to give any kind of actual notice to them about a hearing? Them
Pretty sure they
being
cited due process, the Illinois and the United States Constitution.
Indiana. They're in Indiana. Yeah, like
Indiana and the United States Constitution.
I don't know that there's a world that we live in wherein Richard Allen, and again, always remember that we're talking about Richard Allen's rights here. It's not Baldwin and Rosie's. All right.
No, the only reason we care about them is because Allen cares about them.
Right. So, as far as, well, I mean, I care about them being on because I think that those guys were really working their ass off. I know what you're saying. Right. But like the broader picture is like when we're arguing here about rights, it's Richard Allen's rights. It's not the rights of his counsel because their constitutional rights aren't in play here. So,
right, but Richard Allen had a right to due process before his lawyers either, request to be reinstated or pro bono appearance was declined. He had the right to a meaningful hearing, which he did not get.
Well, I mean, she didn't even bring him into the courtroom, like on the 19th. I mean, she dragged him in, on the 31st and told him, sorry, buddy, I know what you want, but I'm not giving it to you. But in terms of like, and I just don't know if people they keep making the argument that they should have known, that we talked about it in emails and we talked about it in phone conversations and y'all knew and you hired or you had Baldwin or Baldwin had Hennessy prepare something. You guys are sitting here acting like you didn't know that it was coming, and my point is of course they knew that, but that is a far cry. Saying something and doing something are two completely different things, not just in the law, but in life.
But I think that it was fair for them to assume she was going to act on it and set hearing, that she was going to say those things and then set a hearing, not that she was going to try to go to a hearing right then and there when she had just given them the information seconds before.
Exactly. I'm going to televise this. I'm going to tell McClellan to bring all his witnesses in, and then I'm just going to blast you. I'm going to go there because.
So I want you to look at the last sentence on page 15 and tell me whether or not Baldwin and Rossi had the ability or the opportunity to present additional evidence to rebut the court's previous allegations they made in the closed.
So you're talking about this hearing did not occur because defense counsel withdrew rather than challenge the factual allegations at that time. At the October 31st hearing where Baldwin and Rosie attempted to appear for Allen and had their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. So she's talking about two different periods of time there. She's talking about on the 19th.
I'm asking you about on the 31st, did Baldwin and Rossi have the ability to present additional evidence to rebut all the things that she said in chambers on the earlier date?
Well, I mean, if you're asking the question, did she ask the question, what's changed? She kept asking that question. That is what she's referring to. She asked them 3 times when Rosie was addressing the court. She stood up and said, or he stood up and he made his argument. And she said, well, okay, well, what has changed since the 19th? She didn't say anything about, okay, well, do you have evidence? But I guess her argument would be, well, show me evidence. Give me evidence. What evidence do you have as to what has changed since the 19th, where I should change my mind about the way that I feel about it?
I'm fairly certain I recall you telling me that Hennessy stood up and talked about due process and having a hearing and them being given time and the ability to respond to these things that she rose.
No, that was on the 19th. On the 19th, he did that. He said that. Wait, let me think about it. I can't remember if Hennessy spoke on both occasions. Yeah, on the 19th, on the 31st, he went in and made a record. He made the record. I think that on the 19th, I cannot remember for the life of me if he made a record that day as well.
I'm pretty sure I recall you saying on the 31st that he talked about them being given a meaningful opportunity to address the issues raised.
If he didn't do it on the 19th, he most certainly restated it or stated it for the first time on the 31st. He unequivocally got up on the 31st and got into the well of the court. I just can't remember at this point Okay, so Sinbad Sailor is saying he spoke on both occasions. So like I remember, because I remember him firing back at her on what I'm remembering on the 19th and saying, look, this is who we would have had as witnesses. We would have had X, Y, Z, and you didn't allow for that. This is like a, just a sham. But I for the life of me, because I don't know if that took place, because remember, Baldwin and Rosie weren't even in the courtroom when she came out and addressed. I don't know if I don't think he did come out on the 19th, but I might be mistaken. I can't.
But here's my point. If you look at the next sentence, now this again is the Attorney General, okay? And his argument here is that there is a lack of record that prevents review of counsel's disqualification, okay? So he says, respondent, Judge Gulls, raised concerns that could warrant disqualification depending on the circumstances, could, but that the record doesn't give enough information as to whether or not it does. So to me, the Supreme Court should find that a screening issue and at least maybe step in and say, we want you to go back and have a hearing. We want this, I would love it if they could do that, because to me, the Attorney General's argument basically supports all of that. I mean, their argument here is that
I agree. And then that begs the question, can it be Gull who sits on that hearing?
Well, that would have to be, I think, if we were just looking at just that one picture, nothing else Gull did, and nothing about whether Gull should be the judge anymore, but just that there wasn't a full hearing on the withdrawal or the reinstatement, that she would be the one to actually have to do that hearing. That's completely leaving out whether the court were to consider any of these other issues, or whether she should be, taken off the case, or, any of those issues. It would have to be her to go back and do that in this scenario where we're just talking about the fact that there's this one ruling of record that affects the most serious right that a defendant and the people of Indiana and the victims have, for a fair trial and your right to counsel, that has to go back and make a record. Because how do you leave it like this, knowing that, I mean, the argument could be the same, that could be the argument in response to all of this. You could argue, well, I'll tell you why an appeal is not going to be a valid remedy, because there's no record. This hearing wasn't had there was no hearing had. If we don't have a hearing, how is the appellate court going to decide whether or not the judge made the right decision? And they're going to say that the record's inadequate for them to consider it. So there could be an issue, right? That could be an answer right now to why the remedy needs to be a writ. I don't know. I'm kind of, spitballing here.
Yeah, no, I mean, that's what this end period is for. But no, I agree completely. Look, at the end of the day, under no circumstances could what happened in that courtroom on the 19th be considered due process under the law. Just can't be. It's like, I've said it before, I've said it again. Quite simply, you have to give notice. The law, there is no profession that has more rules than the law. I mean, every statute technically are rules. Every criminal statute, every civil statute, those are all rules that if they're broken, that you have to come and answer for them in criminal cases. And like, there are rules for everything. There's rules for judges. There's rules for lawyers. There's rules for citizens. And like that is what everything is in terms of the practice of law. And you have to give proper notice. And like, I agree. I think if they get to the point where they're gonna get to the merits, I think what they should do is kick it back down for the evidentiary hearing, so there can be a record made. And the question becomes, can they allow Gull to be the one to sit on that? I mean, there is no chance in hell she's changing her mind I don't care who it doesn't matter who they're putting on or what they're putting on, because none of that changes the fact in her mind. Like, she's aware of what happened in the office with respect to the leak, the bigger leak. She's aware of what happened with Baldwin accidentally sending the index. Like, they're not going to be able to produce anything that's going to change factually what happened there. So like, for her, there's nothing in her mind that is going to change in terms of no matter what they put on evidentiary wise. You know what I'm saying? Like, there isn't.
So let's look at page 16. Okay. Now, again, Attorney General's response here. We're still going on about him saying, well, maybe there was a basis for that. Maybe there was a basis for the judge to remove the lawyers. So it says that counsel's conduct could implicate a conflict of interest or endanger Allen's ability to impartial jury. Defense counsel permitted 2 separate leaks of protected material, including graphic crime scene images. Now, here's the part that's important for everybody out there who thinks otherwise. Public dissemination of graphic crime scene images could inflame prejudice against Allen. So that is the only concern that the Attorney General is even recognizing. It's the only one that makes any damn sense. No defense attorney wants public dissemination of graphic crime scene images because they could inflame prejudice against Allen. They can't help him. So that's
exactly.
That's
and I see people in the chat, who are like, oh, well, do you think like Baldwin worked with Westerman to get these out to support the Odinism theory? I'm like, dude, no, that is not a thing.
So the next part of this speaks to that. Okay. It goes on to say the record contains incomplete and inconsistent information regarding the extent of the leaks and counsel's role in them. They go on to talk about the affidavit from the friend says that he took them without any knowledge whatsoever, but then that the letter from Baldwin says that he regularly consulted this friend about case and defense strategy. Now I can say I am certain that what he is not saying is not I was sharing all the private, protected information with him, but only I was talking defense strategy, which lawyers do regularly without any specific, reference to something, it's just like spitballing. So he goes on to say, it is unclear whether the friend was given access to protected discovery or privileged information during these consultations. The record also does not reveal what law enforcement learned about the extent of the leak or counsel's role in it, and the investigation appears to be ongoing. Investigations into potential liability for counsel's conduct during representation can give rise to a conflict of interest requiring removal. Again, and we say it right here, whether the circumstances exist that would divide counsel's loyalty between Allen and their own interests is unclear. So again, the record is inadequate. And that is a number one reason why the Supreme Court, I think, should send it back to have all of these things fleshed out to determine whether or not the forced withdrawal or the denial of reinstatement, even if we talk about Rossi, was appropriate, whether it was discretionary power, whether she did, or whether there was any if she had discretion to do what she did in the first place. Whether circumstances exist that would divide counsel's loyalty between Allen and their own is unclear. They also go on to talk about that the record is inadequate for full consideration of Allen's preferences. The record contains expression of Allen's desires to retain Baldwin and Rossi after being informed of the leak, but the record does not show Allen knew or understood what he knew or understood regarding the leak. The court's other concerns about counsel's competence, however those matters impacted his ability to obtain fair counsel or the alternatives available to him. Taken as true, the existing assertions of Allen's preference are insufficient to determine that he is making an informed decision. The presumption of deference to the defendant's choice is strengthened by confidence in that it is an informed and individual choice of the defendant. So these are all things that can still get addressed and can still get resolved. They're by the filing of requesting the interlocutory appeal or in response, relying on the Attorney General's response to in turn say, these are all the reasons why this thing needs to get sent back and an appropriate, hearing has to be had. They go on to say the court's discretionary decision could be reviewed on appeal with a complete record, but the limited review in this action is inappropriate. Courts have discretion to remove counsel for gross incompetence or inappropriate conduct that cannot be adequately addressed through contempt. This requires more than general concerns that counsel is not handling the case as well as they should. So, the Attorney General is recognizing some serious issues here, but he's still saying that a writ is not available where it's a matter within discretion of the court, and still saying that this is such a case. And I think that's only because they're saying that it is appointed counsel. And that's what that whole beginning part had to deal with. Allen has not asked the court to mandate further proceedings, but an outcome. Allen seeks a combination of relief, reinstatement of counsel, removal of the judge, a trial in 7 days that would not permit respondent or any successor judge to undertake further proceedings prior to trial. This is inappropriate to decide whether the trial court abused its discretions. Writs may issue to compel lower courts to act on matters within their discretion, but they are not appropriate to dictate how that discretion is exercised. The balance between the defendant's ability to choose representation and his right to effective representation warrants comprehensive appellate review, not the expedited, truncated proceedings here. Now, again, all of that is just to say he's in one breath saying this should be done on an appeal, but he has also acknowledged that the present record is insufficient for even the appellate court to review to determine whether or not the court acted within, its discretion in removing them. And then in conclusion, they just ask that that the relief is not the relief is not appropriate for resolution. And I don't know. I mean, the Supreme Court probably could say, you know, sort of going to that sentence there about make them do something, not dictate how they should have, the outcome is make them have that hearing. And I know Bob and I don't remember if we raised it with Kara or not, like we talked about that's something they should be asking, like make it go back and make her do the hearing she should have had, cite, rule, law, due effing process. The right to a meaningful hearing. No questions, no ifs, no ands, no buts. The right to counsel of choice and the right to due process before denying counsel of choice. All dependent on it being the pro bono appearance of his counsel of choice as opposed to court appointed, and secondly, due process. And I think all of that is here. And I hope that the Supreme Court will do something, because this does involve such serious issues. But like Bob's saying, the fear is they go on form over substance and say some steps have not been jumped through, some hoops have not been jumped through appropriately, and we're not going to hear it at all.
Yeah, I mean, that's the concern. That's definitely the concern. That, you know,
but you can see the difference here between what the Attorney General said.
The AG is very even-handed. You know, the
Right.
AG is like, the AG is clearly stating with unequivocally that the record is amiss, that it is lacking massive amounts of information in order for anybody to be able to get to these questions and be able to answer it, because the records just got gaping holes, you know, because of the
which i.e. means i.e. the judge could not have made the appropriate decision because she lacked the information to do so. I mean, essentially that's what the Attorney General is saying.
He's 100% saying it. You know, he's also saying, look, they skipped a step. You got to deny it based on that fact, you know, but he makes a lot of very truthful, even-handed admissions about the record and what should have happened. And, you know, so like from that perspective, I obviously respect the response quite a bit, because it's truthful. I mean, everybody, the people that on the other side of this that are knowledgeable about the law all agree. Everyone agrees that an evidentiary hearing should have taken place. And it wasn't Baldwin or Rosie's place to decide whether or not that happens. She says, even if she would have done it without notice and just said, you know what, I know I didn't give you any notice, then they would have been arguing it was improper because they weren't given notice in time to prepare. That's a different argument. Instead, she did nothing when it was her choice whether or not to say, okay, we're going out. I'm not giving you a choice to withdraw. You didn't follow the local rules with respect to withdrawing from the matter. You had to give your notice. You had to give written notice to your client if you're going to withdraw. We're not, like, I'm not going to have you violating those rules. He doesn't know. Like, so I'm going to go out there and I'm going to do the thing. Or in a perfect world, it should have been exactly like what you said. She should have just said, okay, well, we're going to have this hearing and I'm going to give you 14 days to prepare for it. Be ready, because we're coming and this is going down. You know what I mean? It's like, let me see. There were a couple comments.
I was going to say that, you know, some things that the Attorney General said, like when you go back to the beginning on page 7, what I noted as seeming somewhat disingenuous was that he says, when withdrawing their appearances, Baldwin and Rossi claimed it was unfair because they were forced between being accused of misconduct in open court or withdrawing. I take issue with that, because what they took issue with was not just being accused of misconduct in open court, but being accused of misconduct without the opportunity to have witnesses present and evidence to, you know, combat everything item for item, because they had just learned of the complaints and the issues spelled out. Even the judge said, you couldn't have known of this before just now because you're just, it's in the transcript.
Yeah, no, that's like that whole argument's absurd. And again, people that know and understand the law on that side of this are not saying that. Well, that's what if Brett and I were to be talking about that, Brett would have said, yeah, you know, like, because Brett initially had said, look, I think that, you know, they knew, you know, they had notice, but I think at the end of the day, he ended up coming around to the fact that, look, there should have absolutely, they all made a mistake, that there should have been an evidentiary hearing. It just would have been cleaner for her. You know, you've got everybody that's on our side of this thing that's like, man, like, there was no due process here. It's crazy. And then you've got the people on the other side that are like, all right, yeah, there should have been a hearing. Whether they're agreeing that there was no due process or not is of no consequence, because ultimately there should have been a hearing. In order to have a full evidentiary hearing, you have to give notice to the other side for them to have time to prepare. Otherwise, it's just, you know, it's just you're running roughshod over them without their ability to be able to prepare for the thing. And I just want to be clear, these are the responses from the Attorney General and Fran Gull. This is not from Scoyne. I keep seeing comments that people are saying that these are rulings. They're not the rulings, people. So whoever online is saying that these are rulings, they're not. I'm not aware of a court order coming down today. And so if people are confusing these things with court orders, they are not that. They're the responses by both Judge Gull and the Attorney General wanted to sound in as well. So that's what these are. They're not.
Have
They're
you,
not.
have you spoke to Vicky SSV3's comment here?
Oh no, I haven't.
Well, I'll speak to it, because when you're denied your right to choice counsel, they do not decide whether or not the new lawyers even did a better job. There is no balance or weighing of prejudice when you're denied your right to counsel of choice, not your appointment or continuing counsel of choice. And the case law says that there's no way to figure out whether a lawyer did a better job. He was denied the lawyer he wanted. He needs to go back and be represented by the lawyer he wanted. And that's why I'm sort of hoping that the court will take up the issue, because it's an issue that could undo everything down the line, because you can't waive it. And if it was waived, it's clearly ineffective assistance of counsel, because no one would waive such a serious issue so that it can't be, looked at appellate, on appeal.
Yeah. And my whole thing is that when you look at, and this is strictly my opinion, but when I heard, because I had been saying forever that there's no way in hell that they're going to be ready to go to trial January 8th. There's no way, either side. It's too quick. There was way too much stuff pending. There were motions that have to get argued that haven't even been filed yet. There's just no way. So when they came into the courtroom and told her that they had every intention on going to trial on January 8th, and this is back in October, I think, and they had told her that, at least according to the record, they had told her that earlier, that they were intending on going to keeping the trial date, and that they were going to be filing the speedy demand in November. And for people that don't understand, like, the kind of pressure that puts on the state, especially, and look, and you can say whatever you want, whether or not you think McClellan was ready or not, but I could tell you when Luttrell just entered his appearance, I think it was on the 19th of October, that should speak volumes to you that he needed help. And he said it on the record in his, when we got to see the proceedings, when he was introducing Luttrell to the judge back in chambers. He says, "Oh, I just got him in. I finally got the money for it. I needed the help. I've been waiting." He was not ready to go to trial. And you know who else wasn't ready to go to trial? This Judge Gull. Judge Gull, because she's got a full docket. She has an actual full docket in Allen County, which is not Carroll County. It is a very big county. It is a very busy courthouse. It is a huge courthouse. I imagine her docket is swamped, and she has a ton of cases that she's trying to manage. And the prospect of her trying to get through a motion and a memorandum like that Frank's thing probably irritated the crap out of her with respect to the rest of her actual docket that she has to try to manage with who knows how many hundreds of cases that she has on her docket from Allen County. So when she heard the words that we are going to be ready to go to trial, that meant to her that she would have, and understand this. I need you to understand this out there, that if the defendant makes a speedy trial demand and says, we're ready and we are going to trial, we are demanding trial on January 8th, the court has no ability, except for extremely extenuating circumstances, like what is it, Al? Like a witness disappears, or something extraordinary, to continue the trial. If they don't start the trial on that day, Richard Allen, the charges are dismissed. He walks without a trial taking place. It's that serious. There is no messing around with a speedy trial demand. So when she learned in October that they were saying that they were ready to go, and I believe them. I honestly believe that they were ready to go. I think that they had put the work in. I think that they had got the evidence in. And I think that they were ready to go to trial on the 8th. And I think that they understood that the state, and McClellan specifically, was not ready to go to trial, that they had a lot working for them in their favor in terms of going to trial on that date, that when Judge Gull heard it, that it absolutely blew her mind, that she was like out of her mind. And that the thought of her trying to get that memo, like, digested along with all of the discovery, which was 1,500 pages of exhibits and video and all kinds of stuff. And on top of that, she would have had to have heard all the motions that they were going to file after the fact. And after that, try to figure out the timing of getting all the motions in limine done. She would have had to work through the holidays. It would have been a nightmare, part of which by her own making, part of which not because I think that she was doing it intentionally, because she does have a busy docket. But that fact, those things playing together, I think played a huge role in her wanting to get these two guys off the case. That is my opinion. But if you know how trials operate, if you know what goes on in terms of preparing for these trials, the amount of motion work that would have had to have been handled in 2 months, which would have been unbelievable for her to try to schedule and get, because she has no choice. If the defense files a motion to suppress and she's got a looming trial date, which she cannot move because there's been a speedy demand, she has to figure out how to get all that done by January 8th. And I've said it a million times, trial dates when they're looming for, especially for attorneys, but for judges as well, 2 months is nothing. It's the blink of an eye. It just is. I think that in reality that had a huge impact on where she landed on this. And that actually had a bigger impact on her wanting these two guys off the case. I mean, I could be dead wrong, but I don't think that I am. And if you think about it and you know how the law operates and how these trials operate, man, I'm just telling you that thing, that's what happened there. All right. So
I put that up because we got to be fair. Jim paid $2 for his comment, prayers, and support for Judge.
Hey, look, I mean, I've seen Jim and I'm not about trying to censor people. As long as you keep it cool in the chat, like I'm clear on this, man. Like I don't try to pretend like I'm like on this case objective. I am pro defense on this case because I think procedurally Richard Allen is getting screwed, and I care about Liberty and Abby's justice getting served. And if he's getting screwed, they and their families are getting screwed at trial. Like I promise you that. Like we need this thing to go right, and it is not going right, people. It's not. It's a mess. Like what I'm talking about has nothing to do with guilt or innocence right now. I saved that for trial because that's the only time we could talk about that, because that's the only time the evidence is getting vetted. So, man, I encourage people, as long as you can be cool in the chat. I don't care where you're at on this. I really don't. Everyone has an absolute right to their opinion, 100%. And I'll argue it with you. I got no problem. That's what I do for a living. I don't get offended.
You
don't agree? No, I mean, I just, there's I am obvious as to my position in this particular case. If I'm on court TV, I'm being objective. If I'm handling covering a case where I don't have a vested interest in terms of I'm concerned about the constitutional rights of the defendant, which I am in this case, I'm objective. Here, I'm not being objective. I think that it's gone horribly wrong, and it's concerning to me. But I will hear everybody out. I really will. I listen to Brett and Alice's content because I want to hear their side on it, because it's important for me to know that. I need to know what their side on it, because they're bright people and I respect them, and I want to hear what they have to say about it. And anybody else that's bright and knows what they're talking about, I want to hear their position on it. I'm not going to get into, just like anything that is complete speculation about the evidence or the leaks or why it happened or who did it. I honestly don't care about that. I wish that it wouldn't have happened. First and foremost for the families, because I hate the fact that they had to deal with the thought of that being out there. And secondly, for Richard Allen, because it's created this nightmare that gave the judge the opportunity to boot these guys. Because again, I am firmly of the position that this looming trial date, which they were going to file that speedy demand, put incredible pressure on Gull to try to squeeze this stuff in 2.5 months, which is nothing. So, all right. So we've got to give some shout outs. We're going to wrap it. It's been 2.5 hours. I got to go on court TV anyway in 45 minutes. So of course, talking about Delphi. The case, Griffith, $5 holla, very much. We thank you. Gabby, new member, we appreciate you. We love having you in here. Debbie, $2 holla, appreciate you. Melinda Driscoll, welcome to the party. We're glad to have you. Matt Thomas with a $20 holla, appreciate you. Just want to say, so appreciate both of you breaking down the complex legal terms actions. This is such a strange case so far. We agree, dude. We absolutely agree.
Thank you very much.
Thank you very much for that incredibly generous $20, man. Desiree D, $10 holla. Hey, Bob and Allie, welcome back. I tuned in late, so maybe already addressed. I'm thinking Allen's new counsel needs to file something on his behalf on the double. Have they filed anything since 10/31? You are late.
So
you are late. And we did address that. We agree completely. He's got to get a letter to his new counsel saying you need to file an interlocutory appeal relating to what happened on the 31st. So we're in complete agreement with you. And yes, we did address that. But thank you for bringing it done
by the 30th.
Yep, it's got to get done. All right, so that's it, y'all. Thank you for joining us last minute. And y'all, it's not Allison's mic; it's her computer. I got to get her a new computer. She's got way too much memory, or not enough memory, so that's why she's choppy. She actually has my mic, so her sound's good, but her computer's choppy. We're working on it. We're working on it. It'll get better. I promise. I'm getting her a new computer, so she'll be smooth as the day is long. So, all right, y'all. Thank you so much for hanging with us. If you're available, check me out on Court TV.
Another super sticker. Gotta put that up there.
Oh, yes, Griffith killed it with ooh-wee. $20 holla. Thank you, Griffith. We appreciate you.
We also did the sticker earlier.
No matter what side you're on of this, we love all of you. We love the engagement. Just be cool. Just be kind to each other. It's a simple rule. We can disagree. It's the American way. It's how this country was formed. So disagree all you want. Disagree with us. We're here for it. And just remember, without y'all, I'd just be an old man.
Hello, it's me. I will be right back in let's see. I have it set for 9:30 Eastern, but I might move it up. Yep, I'm moving it up an hour. So 8:30 Eastern, I will be back live with Chad Daybell's hearing. I'll see you then. Have a good night.